Knott is currently 47 years of age and has been incarcerated for over 24 years. He may very well be the most rehabilitated prisoner in the state of Georgia. Knott has shown a remarkable pattern of self-rehabilitation throughout the years and continues to do so at present. His incarceration began on December 31, 2000 for armed robbery and other related offenses involving no physical violence. This is his story of self-rehabilitation and continual fight for justice. Knott was born in Detroit, Michigan on July 7, 1977, to Bernard and Cynthia Knott. As a child, Knott was always in some sort of trouble. However, despite his problems, he was very intelligent. His teachers saw a lot of potential and worked with him consistently. Knott was also dearly loved by his friends and family. In July of 1994, at the age of 17, Knott was arrested in Cherokee County, Georgia, for a pawnshop burglary, motor vehicle theft, and receiving goods obtained by fraud. In November of the same year, Knott was charged with aggravated assault and aggravated battery. He was subsequently sentenced to serve 5 years and sent to Alto State Prison, known as the Toe, likely the most violent prison in the state of Georgia at that time. During his first incarceration, Knott was extremely rebellious. Having received 38 disciplinary reports, he served all 5 years of his sentence. Knott was released from prison on January 3, 2000. He was gainfully employed with Integrated Health Services as a dietary aide, then quickly promoted to relief cook and supervisor. His future looked promising. It is wholly believed that Knott's decision to engage in illegal activities stemmed from the poverty-stricken conditions that he found his mother and 11-year-old sister living in. On December 28, 2000, felony warrants were issued for Knott's arrest in Cherokee County, Georgia. The charges included armed robbery, kidnapping, burglary, and possession of a firearm. He was later charged by other law enforcement agencies with additional offenses. Knott was ultimately convicted on all charges. Now, in order to understand the gravity of the turning point in Knott's life, it is necessary to mention a much-noted fact about him. He is the epitome of a mama's boy. He has always loved his mother, Cynthia, more than anyone else on earth, by leaps and bounds. The truest love he's ever experienced comes from his mother. She's the only person in his life who has never once given up on him. The turning point for Knott was on March 13, 2002, during his sentencing hearing. His mother, true to her love for him, and the only person there on his behalf, stood before Judge Mills in open court, eyes full of tears, and begged that Knott be shown mercy, even blaming herself as a mother for the many woes in his life. At this point, Knott, with tears in his eyes, listening to his mother's plea, vowed that he would not leave this earth without becoming a man she would be proud of. He was then sentenced to serve 61 mandatory years in prison. However, Knott would still hold true to the vow that he made to himself that day.
moment has arrived.
Do that.
The charge. Now I want to bring up the faith and character aid. I was going to give him this great thundering introduction, make him look good and everything, but I thought about it and I said to myself, self, he don't need one. So without further ado, the director of smooth ability during the storm, Mr. Knott.
Good morning, everybody. If there's any remote doubt in your mind that you can accomplish anything that you set your mind to, then that's a tragedy. There shouldn't even be a gray area in your minds. Because the reality is that in this life, you will either be a winner or a loser, strong or weak-minded, focused or confused, an excellent or a poor example of a man. If any of you thought that you just came to a prison event to make your graduation from the Faith and Character program official, or just an opportunity to eat a little free world food, then you've greatly missed the point. Those of us striving for success know as a chess master that every move we make, and like Bobby Brown, every little step we take is vitally important. Malcolm X said that the future belongs to those who prepare for it today. So this is not a game. This is a part of our legacy in the making, an accomplishment that is a positive step in the right direction. But we must also never lose sight of the unavoidable fact that the struggle is real, that pain is real, that the hardships and the trials and storms of life are real. But we must also know, as Frederick Douglass stated, you are not measured by the height you have risen, but from the depth you have climbed. Now, the depth in which we currently exist and the climb that we are required to make will surely propel us to greatness. Let's keep it real. We are surrounded by chaos, uncontrolled violence, addiction, hopelessness, despair, and death. Yet, we sit here as men who saw a light in this darkness, a sun ray shining in the midst of this storm, and we've seized the opportunity. Indeed, the ultimate measure of a man is not where he stands in moments of comfort and convenience, but where he stands in times of challenge and controversy. So said Martin Luther King Jr. Now we must stay the course. We must never, ever, ever give up. As wisely stated by Nelson Mandela, the greatest glory in life lies not in never falling, but in rising every time we fall. Know that there is nothing more essential to your success than education. Ignorance will be the greatest enemy to you reaching your highest potential. Forever live by the faith and character mantra of no excuses, as excuses are a main ingredient to failure. Be vigilant, committed, focused, on point, stay tight and ready. Put forth no effort at all unless it's your best effort. And dream big dreams, because surely it always seems impossible until it's done. The humble yet wise men that I've quoted all lived in captivity, either enslaved, jailed, or in prison. Yet, they became great, and so can we. Congratulations, my brothers. Thank you.
Sean turned down the state's offer to plead guilty and served 12 years in prison, followed by 8 years on probation. Instead, he exercised his constitutional right to a jury trial. Sean was found guilty at trial and sentenced to serve 61 years in prison without parole. After being given such an excessive sentence, Sean immediately began the process of learning about the law. He would eventually discover that he was arrested without probable cause, which violates the Fourth Amendment to the United States Constitution. When this happens in a criminal case, any evidence seized at the time of the illegal arrest must be excluded from trial. Yet, in Sean's case, the evidence was used to convict him. Sean's trial lawyer, John Knuckles, did not challenge whether probable cause existed for the arrest, which allowed the district attorney to use the evidence at trial. For this reason, Sean's trial counsel was ineffective, which is a violation of the Sixth Amendment to the U.S. Constitution. Sean's appeal lawyer, Jonathan Kessler, did not raise trial counsel's ineffectiveness, so in 2005 the appeal was denied. After the denial, Sean retained attorney, August Bud Seaman, to represent him in a habeas corpus. A habeas corpus is a proceeding specifically in place to ensure that a person is not incarcerated in violation of the Constitution. The situation now becomes particularly significant, as it will highlight the court's clear disregard for the U.S. Constitution in the rulings related to Sean's case. At the habeas corpus hearing, Bud Seaman raised the issue of ineffective assistance of both trial and appellate counsel. He presented documentary and testimonial evidence showing that Sean's arrest violated the Fourth Amendment and that the property seized during the arrest, his car, cash money, clothing, and shoes, should have been excluded from trial. Surprisingly, but very significantly, Jonathan Kessler, Sean's appeal lawyer, read the affidavits for arrest under oath at the habeas corpus hearing. According to Mr. Kessler, the arrest warrants were in fact supported by probable cause, which is why he did not raise the issue on Sean's appeal. You will see the significance of Mr. Kessler's assessment later. Judge Clarence Blount presided over the hearing. In his ruling denying Sean's habeas corpus petition, he stated,
"Petitioner's claim is fundamentally flawed. There is no indication that the evidence was seized as a direct result of the arrest."
Sean knew that Judge Blount's ruling was factually flawed and inconsistent with the provisions of the Constitution. Now representing himself, Sean filed a federal habeas corpus petition challenging Judge Blount's ruling. In response to Sean's federal habeas corpus petition, Magistrate Judge Geraldine Brill recommended that the petition be denied. She stated the following:
"I determine that petitioner has failed to show that his arrest warrants lack probable cause."
Sean objected to the recommendation, emphasizing to the court that the evidence obtained as a result of his illegal arrest should have been excluded from his trial. He insisted that his trial and appellate counsel were both ineffective for failing to challenge this constitutional violation. In response to the magistrate judge's recommendation and Sean's objections, District Court Judge Steve C. Jones denied Sean's federal habeas corpus petition. In his order, he stated,
"After carefully reviewing the R&R, the court agrees with the magistrate judge that petitioner has not shown that his arrest warrants lack probable cause."
Sean was completely baffled. How could a federal judge deny that such a clear Fourth Amendment violation had occurred? He soon realized how naive he had been to believe that proving a constitutional violation, which led to an unfair trial, would result in the relief required by law. Sean has no doubt that the judges who denied him thus far were fully aware that their rulings contradicted the United States Constitution. At this point, however, he didn't understand why this was happening, but more will be revealed. The injustice continues. After District Court Judge Steve Jones denied his federal habeas petition, Sean sought to appeal by requesting a certificate of appealability, known as a COA, from the 11th Circuit Court of Appeals. A certificate of appealability is required when a petitioner seeks to appeal a decision in a federal habeas corpus case. This is because, in such cases, the petitioner cannot automatically appeal the district court's decision to the Court of Appeals. The COA serves as a permission slip. The standard for granting a COA is relatively low. The petitioner, in this case, Sean, was only required to show that there's a reasonable argument to be made that the district court judge's assessment of his constitutional claim was debatable or wrong. In his request for a certificate of appealability, Sean argued that the state, magistrate, and district court judges all made errors in their rulings. Specifically, he contended that 1. His arrest was indeed illegal. 2. As a result, the evidence seized at the time of the arrest and used to convict him was tainted. And 3. Therefore, both his trial and appellate counsel were ineffective. On July 10, 2015, 11th Circuit Judge Jill Pryor ruled on Sean's COA request. In her ruling, she stated,
Mr. Knott has presented evidence that his arrest warrants were based solely upon probable cause affidavits, and those affidavits contained only conclusory assertions that Mr. Knott committed the offenses. Thus, it appears that Mr. Knott was arrested pursuant to arrest warrants that lacked probable cause. The items seized at the time of Mr. Knott's arrest would have been suppressible.
This conclusion directly contradicted the earlier assessment by District Court Judge Steve C. Jones, who ruled that the arrest and evidence seizure was lawful. Accordingly, Sean had clearly met the legal standard for being granted a certificate of appealability, allowing him to pursue his appeal. However, it was still not to be. Although Judge Jill Pryor's conclusions made it a requirement that she grant Sean's COA request, she denied it anyway. Not only that, she did so in a way that the United States Supreme Court says is forbidden. Without jurisdiction, Judge Jill Pryor decided the merits of Sean's ineffective assistance of counsel claim. The United States Supreme Court has ruled. Until a COA has been issued, federal courts of appeals lack jurisdiction to rule on the merits of appeals from habeas petitioners. Yet, this is exactly what Judge Pryor did. In her order denying Sean's COA, she stated,
Because Mr. Knott's ineffective assistance of trial counsel claim would not have succeeded, appellate counsel was not ineffective for failing to raise it on appeal. For these reasons, Mr. Knott's motion for a COA is denied.
Here's what's interesting. Before and after Sean's case, the 11th Circuit Court of Appeals has always cited and used the correct standard for reviewing a COA. For example, in the case of Pippin versus Dretke, the 11th Circuit stated,
In determining whether to grant a petitioner's request for a COA, the Supreme Court has instructed that a court of appeals should limit its examination to a threshold inquiry. This threshold inquiry does not require full consideration of the factual or legal basis adduced in support of the claim. In fact, the statute forbids it.
Also, in Mims versus United States, the court stated,
Importantly, analysis of a COA is not coextensive with a merits analysis, and denying a COA by reaching the merits of an appeal is essentially deciding an appeal without jurisdiction.
Judge Jill Pryor is a member of the 11th Circuit. However, in Sean's case, she went against her own circuit's precedent, the instruction by the U.S. Supreme Court, and thus the interest of justice. In her order, she never even mentioned the standard of review for a COA. There is really no question about it. Judge Jill Pryor did not have jurisdiction to decide the merits of Sean's ineffective assistance of counsel claim. In fact, the United States Supreme Court has overturned cases where circuit courts have done this exact same thing.
This is the whole point, really. They're not supposed to be doing what you would do when you decide an appeal. I mean, they actually don't have jurisdiction to decide the appeal. I mean, they're supposed to be performing a gatekeeping function, not deciding the merits of the case.
In McCoy versus United States, another 11th Circuit case, it was established that
The jurisdictional defect is one that strips the court of its power to act and makes its judgment void.
accordingly, Judge Pryor's ruling on the merits of Sean's constitutional claim is void. Sean has repeatedly stated this fact in his filings. What exactly is a void judgment, according to the law? It is a judgment that has no legal force or effect. From its conception, a void judgment continues to be absolutely null. It is incapable of being confirmed, ratified, or enforced in any manner or to any degree, and may be challenged at any time. One example of a void judgment is the lack of subject matter jurisdiction. What does the United States Supreme Court say about the status of a void judgment?
A void judgment is one so affected by a fundamental infirmity that the infirmity may be raised even after the judgment becomes final.
Even a basic Google search reveals that a void judgment may be challenged at any time. Now, it gets really good. Sean was now equipped with clear authority that a void judgment can never stand and may be challenged at any time. He believed that once he showed this error to the court, the void judgment would not be allowed to stand. However, the following documented proof will show that Judge Jill Pryor ensured that the void judgment would not be corrected. Sean's first 3 motions, seeking to correct the void judgment, were returned to him, unfiled by the Clerk of Court, David J. Smith. Sean advised the clerk that civil litigation would be pursued against him if he did not file the motion with the court. As a result, the clerk filed Sean's next motion. This time, however, the clerk was ordered by the court to return Sean's motion unfiled and to accept no more filings from him. Guess who gave the clerk this directive? Judge Jill Pryor, the same federal judge who issued the void judgment. In her order, she never denied that the judgment was void. She simply directed the clerk not to accept Sean's motions challenging it, ever. Remember, there isn't a law in existence that prevents a person from challenging a void judgment. Sean continued to fight diligently, seeking relief from the void judgment and ultimately his unconstitutional conviction. However, the order given by Judge Jill Pryor, blocking him from filing in that court, proved daunting. Several years passed, but through constant research, in 2021, Sean finally found what he believed to be the way to challenge the void judgment. There is a federal motion specifically in place to reopen a closed case. Its purpose is to address an error that occurred in the course of the appeal process. It's called a motion to recall mandate. After filing the motion, here is the response Sean received from the 11th Circuit Court of Appeals on May 5, 2021.
The court has received your motion to recall mandate. The court is not accepting filings in this closed appeal.
Keep in mind that this motion is specifically designed to reopen a closed case. Also in 2021, District Court Judge Steve C. Jones threatened sanctions against Sean if he continued to file motions in that court related to the erroneous rulings issued in this case. Yet, He is the same federal judge who issued an order that directly contradicted the provisions of the United States Constitution. In December of 2023, Sean sent a letter to the 11th Circuit Court of Appeals requesting a copy of Judge Jill Pryor's COA order. In response to the document request, the court sent a letter to Sean stating that he had made a deficient filing and, under action required, went on to direct Sean to file a motion to recall mandate if he met the standard to do so. Taking the court's directive, Sean filed another motion to recall mandate. On May 22, 2024, this is how the 11th Circuit responded to the motion.
Sean has only exercised his right to challenge the integrity of his conviction in incarceration. He has fought valiantly over these many years, and even with the Constitution and rulings of the United States Supreme Court squarely on his side, the court still ruled against him. In this case, the discrepancies, irregularities, and outright violations of law and morality were committed by the judges, whose oath and duty require that they not only uphold, but also protect Sean's constitutional rights. It is imperative that courts be made to prioritize justice, fairness, and the integrity of the criminal justice system over the finality of convictions. Sean is serving 61 years in prison for a conviction riddled with glaring constitutional violations, which he presented to the court 13 years ago. Based upon the evidence presented in this video, there can no longer be any confidence in the integrity of Sean's conviction. Accordingly, it is in the interest of justice and fairness that Sean's conviction be vacated.